Hi there, I'm Ron Wright. I teach at the law school here at Wake Forest University, and we're going to be talking today about a criminal procedure topic. The idea is speedy trial. Once the government has decided to bring charges, or even while it's thinking about bringing charges, they can't just wait around forever. They have to get on with it and either charge you or not. There are certain rules from both constitutions and statutes that tell the government how quickly they have to move in getting the charges filed and tried. So we're going to talk about speedy trial. Let's go in. Okay folks, let's get started. We're going to be talking about speedy trial. There are different aspects to speedy trial. There are time aspects and there are source of law aspects. I start off with a couple of slogans. Sometimes we say, justice delayed is justice denied. It's not an especially good thing if a crime happened or an alleged crime happens, and then it's 10 years or 20 years or 30 years before we finally get it tried. There's something wrong with that. We want to move along and get some kind of criminal law response to a crime when it happens. So sooner would be better. Justice delayed is justice denied, we say. On the other hand, sometimes we say, haste makes waste. We don't want to go too fast, we want to get it right. When you're going too fast, you make mistakes. Mistakes can be truly tragic in this area. So you want to go fast, but not too fast. You also have the parties themselves with different incentives. So if you're talking about delay between the time when the event happens and the time when the government charges the case, well, the defendant is normally pretty much okay with that kind of delay. Sure, take your time, I can keep living my life in a normal way. I'd rather you just never get around to it. And the government is, we need to hurry up and get this done. So pre-charge delay, the government tends to be in a hurry and the defendant is just fine, take your time on this. Post-charge delay is a little bit different. So there's the moment when the government files its charges, and then you've got to get ready for the trial and do the discovery and file your motions and all the preparation that the lawyers go through, and then you have the trial. And if that process stretches out too long, who's unhappy with that? Well, very often, rule of thumb, the government's still unhappy with this. They want to get their case proven. It's inconvenient for witnesses to have to come down to the courthouse all the time to keep getting ready for a trial, or maybe their witnesses forget what happened, memory fades after a while, and so there are a lot of situations where the government is also pressing for quicker resolution during the post-charge period. But there are sometimes when a defendant would say, look, I've been charged, there's this cloud hanging over my head, I'm paying a lawyer, the bill keeps going up and up and up. I want to get this over with. Come on, government, prove your case, get on with it. So there will be times when it's the defendant who's wanting this speedy trial to happen. Let's talk first about the pre-charge period. What kind of law encourages the government, maybe even forces the government to get its act together, get the case proven, and file the charge? Well, you've probably heard television, movies, other places, the statute of limitations. There are very often statutes that a state legislature will pass, and the statute will say for certain kinds of crimes, the government has 2 years to pull its evidence together and to file the charges. And if they don't file the charges within the 2 years, then they have to just give up on it. Time to move on. You shouldn't have to worry years and years and years about what's going to happen about that possible, loaf of bread that I stole, 10 years ago. We don't like the idea of Jean Valjean, stealing a loaf of bread and having to run for his entire life away from the persistent, tireless, heartless government investigator. So we do say, for certain crimes, we just give you a time limit, and after that, you have to drop it, government. You can't go after somebody after that point. There are certain crimes as you move up the scale, more serious crimes where the statute of limitations gets longer and longer. And for certain crimes, you've probably heard this on some cheesy television script, there is no statute of limitations for murder. And that's true under most state codes. That is, you get the very most serious crime, there's no statute of limitations at all for that most serious crime. So you will typically find statutes of limitations that have shorter time periods for less important crimes, longer time periods available for the more serious crimes, and maybe no time limit at all for murder and possibly a few other very serious crimes. It's also true that there are certain things that a defendant can do that will freeze the clock. So if the defendant intentionally hides evidence, or if the suspect who hadn't been charged yet sort of leaves the country and stays out of sight for decades at a time, then in many jurisdictions that will freeze the clock and the government could still charge after a while. You see this kind of statute, for instance, with child sex abuse, where if you abuse a child who's quite young and they don't know how to speak up, and then it's only when they become an adult that they say, now I realize that was a crime, I need to say something. In that kind of situation, state law very often says we will freeze the clock if the crime happens to a minor. So at any rate, those are statutes of limitations. There are a few states there's at least one state that has no statute of limitations at all, and other situations where, as I've said, the statute of limitations doesn't apply, and still we might say it just gets to be too long. That's just really extreme. 30 years and no charges, and all of a sudden now you're going to charge for that thing that happened 30 years ago. So there is a constitutional limit on this, a due process-based limit, where the courts will come in and say, even though there's no statute of limitations, even though the legislature has not given the government a time limit, there's just a certain point at which we, the courts, have to insist on prompt action. It's just been too long, you can't bring the charges. Obviously, this is reserved for very extreme cases. It's quite a rare situation, but occasionally you'll see it happen. There's some due process cases from the 1970s, Marion and Lavasco. Marion from 1971 and Lavasco from 1977, two U.S. Supreme Court decisions that talk about this due process doctrine. And they basically ask, what were the reasons that the government had? Did the government delay because it was just trying to find more evidence and it had to keep working and it was hoping for some lucky break in an investigation, but they didn't have the evidence until then? If that's the case, fine. Delay can happen and you can still go ahead with the charge. On the other hand, if the government's waiting around to get some unfair advantage, for instance, there's a key defense witness, we'll wait till the witness dies and then we'll bring charges, and now that you can't defend yourself, the due process limitation might kick in there and say, no, you have to, that's an improper reason for delay and we're going to block you from bringing these highly delayed charges. Or perhaps, a prosecutor refuses to bring charges and then later some family members of the victims, lobby and they, get that prosecutor thrown out of office and put a new prosecutor into office and say, now you need to bring charges because, we delivered the goods for you politically. Again, that might be a due process problem if there's too much delay in the pre-charge period. But that's the basic legal framework there. Mostly statute of limitations, legislature creates the time limits, with an occasional backup from the courts on this due process theory if the government has improper motives to explain its delay. But let's turn next to the post-charge delay, the delay between the time when the government files charges and the time when they can actually get the trial started. So if that gets to be too long, again, there's a problem. Let's start with the constitutional doctrine here. There's a case called Barker versus Wingo. It has a 4-factor test that says the courts will look at these 4 factors to decide whether there's been too much delay here. What are the 4 factors? Well, first the courts say, we ask about the length of the delay. How long has it been? If it's only 6 months, 8 months, 10 months, probably not enough. And the courts just say, we're not even going to ask about the other factors until you can clear a threshold of a certain amount of delay, a length of delay. They never say exactly what the triggering moment is, but they say it's got to be enough to be a serious kind of delay that gets our attention. So first, length of the delay, a threshold factor. And then if you have enough for length of delay, then you can start thinking about these other factors that all just kind of go into a stew together. So the second factor would be the reason for the delay, like who asked for the delay, why was it happening. The third factor would be, did the defendant ask for a speedy trial? Was the defendant just staying quiet saying, oh, this is great, you're delaying, and I'm going to sneak up on you and spring a speedy trial motion on you eventually, instead of the defendant saying, hey, get on with it, this is messing up my life, come on, try me. If it's the latter, then that's a factor in favor of the defendant, if the defendant is pretty consistently asserting the right to a speedy trial. And then the fourth factor is, was the defendant prejudiced? Was the defendant, stuck in jail pre-trial, or were records or other evidence deteriorating or disappearing, or in some way was the defendant's ability to put on a defense more difficult because of the delay? So you ask about prejudice. You put all four of those together and you end up getting a ruling. The most important two of these would be the prejudice factor and the reasons factor. And very often with the reasons, what you'll see courts doing is they'll split the periods of delay up, and they'll say, okay, for the first 90 days, it was because the defendant decided to switch attorneys. But then from that point till out to the 2-year mark, it was because the state was waiting for results from the state crime lab. And so that'll be the state's fault. And then from that point to the next, it was because the judges ran out of courtroom space and they kept rescheduling the trial. So, you go through with different periods of the delay and you ask, who asked for the delay and was there a good reason for it? And the factor can either count strongly against the government or weakly against the government, or weakly against the defendant or strongly against the defendant. But you split up the delay periods and you ask whose fault was it and how much at fault were they? Was it a weak or a strong factor against that party? Some of the hardest questions here involve whether you should attribute things like backups at the state crime lab to the local prosecutor's office. Local prosecutor says, hey, wait a minute, that's over in the state capitol and we have nothing to do with that and you can't blame us for that. But the typical outcome here is, look, it's the state government that's funding the prosecutors, the courtrooms, the crime labs, so they should be responsible for all of those different kinds of delay. The defense attorney might be paid by the state as an appointed attorney, but defense attorney delays are not attributed to the state. They're attributed to the defendant. So that's the constitutional doctrine or the due process doctrine under Barker versus Wingo. One last area of control over this delay, these non-speedy trials, and that is a Speedy Trial Act. Almost all states have some kind of statute that says in our state courts, once you have filed a case, the clock is ticking and you have to get the case processed, finished before the buzzer sounds, before the deadline arrives. And so the different states are going to declare different deadlines. In some places it's 70 days, in some it's 90, in some it's 120 days. I'm not going to bore you going through all 50 states and all their different deadlines, but the basic idea is that there's an amount of time that state law normally allows for the processing of cases. There are also typically freezing events or tolling events where something happens and you just stop the clock for a while and the days after that don't count until you restart the clock. So very often if a party files a motion and says, Judge, before we go to trial, I want you to give me a pretrial ruling on this question about whether the evidence can come in or not, then under the speedy trial statutes in a lot of states, the clock is frozen during that period when the judge is thinking about it and ruling on the motion from one of the parties. So that's the basic structure of these statutes. They declare a time period. The clock is ticking during that time period. It's frozen for certain events in the litigation, and then the clock restarts. And if it dings, if the state runs out of time, then they can't bring the case anymore. They ran out of time and there is no conviction that's possible. The remedy is dismissal with prejudice, as we say. That is, dismissal and you can't come back and refile the charges again. So those are the different ways that we try to control for proceedings that are too slow. Either the filing of the charges was too slow, or the processing of the trial, the arrival of the trial is too slow. It can be governed either by statutes like the statute of limitations or the Speedy Trial Acts, or by the Constitution, the due process limits of Barker versus Wingo, or pretrial, the Lovasco or Marion cases. Lots of different methods we have of making sure that justice is not delayed and therefore justice is not denied.